Do you have to file a will in Wisconsin? Hello, I'm attorney Thomas Burton, and that's today's question. I sometimes get asked this question by clients right after we sign their will or estate plan. The answer is Wisconsin Statute 856.05 says that the original will for every deceased person shall be filed with the Register and Probate within 30 days of death. So I would direct you exactly to Wisconsin Statute 856.05, but it requires the personal representative, if they have the will, to file it with the probate register, or it requires someone else, if they have the will and knowledge of the death, to file it within 30 days knowledge of the death. So even if there's not a probate required, the statutes say you should file the will with the Register of Probate in the county where the decedent died. Now, this is from the Register and Probate website, not strictly the statutes, but what they say. Pursuant to Wisconsin Statute 856.05, the original will for every deceased person shall be filed with the Register and Probate within 30 days of death. This is what they say. If a probate proceeding is required, you may file the original will at the same time you file the initial documents to open the administration. If no probate proceeding is required, please contact your local Register and Probate office to make arrangements for the filing of the decedent's will. So you have to file the will whether there's a probate required or not. And in Wisconsin, the small estate probate limit is $50,000. So sometimes if the assets subject to probate are less than this, you won't need to file a probate, which is ideal. Or if all of the assets pass under the revocable living trust, you wouldn't need to file a probate. But I still advise my clients to file the will, even if it's what we call a pour-over will, a will simply designed to pour over assets into the trust, to file it within 30 days of death. Now, they say on the Register and Probate you could wait to file it with the probate documents, and I know that in practice some people do this because that 30-day limit, from what I've heard, it rarely gets prosecuted, but sometimes it can take you a while to open a probate, so I often prefer to get that will filed within the 30 days, and then you can work with the attorney to get the probate court documents filed at a later date. So discuss with your attorney their preference on this in the county where you're in if you're dealing with a probate. But the statutes say 30 days from knowledge of the date of death, and that's what I would go with when you're thinking about filing the will. Now, that's after death. A will is private during your life because you can revoke or amend it or change it. Amendment to a will is what we call a codicil. So you don't have to file it during life, but after death, the person who has the original will needs to file it. So that leads me to the second part. Sometimes I get asked the deposit of the will for safekeeping. And the Register and Probate covers that right after that in this post on their website. That's Wisconsin Statute 853.09. It says you, the testator, that's the person who makes the will, may deposit your will for safekeeping with the Register and Probate of the court in the county where you reside. However, they note not all Register and Probate offices accept wills for safekeeping. So there's 72 counties in Wisconsin. You need to check if yours even offers this. Contact the local Register and Probate if you have questions. There's a statutory fee of $10 for this service. The will must be in a sealed envelope with your name and address noted on the outside of the envelope. The Register and Probate will provide you a receipt at the time of deposit. So sometimes people ask me if they should do this. My answer is you can if you want to, but I would think about, is this your very last will you plan to make? If it is, maybe you want to file it so it's already on file there. If you think you may change or amend your will, just remember that if you do change or amend the will, which you can do at any time during your life, you would need to go get that will from the Register and Probate and replace it with the new one so they have the correct one on file. So for some people, they are willing to do this. For others, it sounds like a hassle. The other thing I would say is think about if you plan to move, because if you move from one county to another, you would want to remove that will from the county where you filed it and put it with the other county. That's why in general, I recommend clients keep it in a safe place in their home, such as in a safe, fireproof safe, or other lockbox, because they cover that next on the website, this post. If you need to withdraw your original will, you will need to provide the original receipt that was given to you at the time of deposit and photo identification. The original will can only be removed by you, the testator, personally, or by a person authorized by you, the testator, by a writing signed by you, the testator, and 2 witnesses other than the person who will be withdrawing the will from safekeeping. So really, to me, once you put your will there for safekeeping, it strikes me as something you want to do when you're convinced this is my last will ever, and I'm worried about someone trying to produce another will to challenge it or change it, because there is extra hassle to get it out of the register and probate, which isn't wrong. They want to make sure someone's not up to anything funny, trying to withdraw the will without your permission. But as you get older, sometimes you're unable to physically go down there anymore, or during COVID, when many government offices were closed to the public, things like that, it could be more difficult for you to get down there with the photo ID. And then you can use that signed statement method, but it's still going to be more work for you to go withdraw the will and then execute a new will or a codicil to change it with your attorney and then put the new one down there. So again, you think about your own situation, what you're looking to do. If you have a significant estate that you're planning to flow through probate using the will, and a lot of relatives who don't get along, who are litigious, who you think are out for money, you might want to take these extra steps and get that will on file prior to your death. If you don't have that situation and you think I may move or change my will, you may not want to take the extra steps, because it is just a little more hassle for you the next time you want to change or amend your will through what we call a codicil. And nowadays, many people, when we change a will, we simply execute an entirely new will, because with word processing software, it's not like someone is typing up a codicil to a will, and that codicils, to be honest, can get confusing when you start attaching too many codicils to a will. It can be a little confusing which is the original will and what is the codicil modifying which version of the will, things like that. So I wouldn't encourage doing too many codicils to a will. You'd be better off just doing an entirely new will, which revokes the previous one, and then the most recently dated will would be your valid last will and testament. But in general, that's why I don't even like using wills for estate planning, because of all these difficult requirements with the witnessing and the execution and the filing and such. And I generally favor avoiding probate on your assets to avoid the time, expense, and delay of probate. But if you are using a will plan to pass your estate, this is the method for filing the will after you're gone. And if you want to file the will during lifetime for safekeeping, again, it's going to depend if your county allows it, and then you would pay that statutory $10 fee and follow the procedures there. So if you're wondering if your county does it, I would Google register and probate office name of your county, go to their website, see if it's offered, and coordinate it directly with them to get your will filed during your lifetime. So I know this question comes up in other contexts, other states and things like that, but that's the process in Wisconsin. If you want to file a will, the answer is yes, mandatory to file the will after you're gone. No, not mandatory to file during lifetime, but you may if you want to. You pay a fee and go through the process discussed here. So I hope this video was helpful to you. If it was, please consider giving it a like so others can see and benefit from this information as well. Thanks for watching, and we'll see you next time.